Welcome back! Today we're going to talk about discovery and in its pre-trial phase, so we're going to figure out what everybody knows. Nobody's going to know. Everybody's going to know. You have to find out el chisme del pueblo. What do people know? What do they need to know? What don't they know? Let's dive in! Important that you stay until the end of the video so you can see the chart that I prepared for all you visual learners to see exactly what I'm talking about in a more wordy way, if you catch my drift. Okay, let's dive into Discovery Pre-Trial Edition. For Discovery, to find out what everybody knows, what do you need to do? Communicate. Communication can be the basis of solving most of our problems, but yet it's something that many people do not like to engage in. Anyways, so how do you communicate? The first thing you do is disclose. What do you disclose? To whom do you disclose? When? Where? Let's go one by one. What do you disclose? You disclose things that you know. Plaintiff and defendant must disclose everything. But you're like, okay, yes, that makes sense, but how do you apply it to every day? So we'll have a scenario. I went to the grocery store. I went to the grocery store to get some liquid. I'm not sponsored, so why should I reveal their name? Anyways, I went to go grab it off the shelf, but the cap, someone had come in earlier and decided to take a drink from it, and I didn't realize it. So when I pull this beverage off of the shelf, boom, spills everywhere. I take a step, boom, I fall to the ground and I hurt myself. I hurt my knee and my tailbone, and I cannot get up. Who is the plaintiff and who is the defendant in this scenario? I am the plaintiff because I'm going to sue the grocery store. The grocery store is a defendant. So what would we have to disclose here? We would have to disclose the security camera footage. We're in the 21st century, so you best believe that there's going to be security camera footage. I also forgot to mention that there was this older lady walking by in the same aisle when I had my slip and fall. That is a potential witness, a lay witness. I'm going to go into more detail the difference between lay and expert witness in a bit, but these are important things to disclose. It's also important to disclose if I had insurance and the amount of damages. I went to the doctor after. What does my bill say? That I need to get a surgery? How much is that surgery going to cost? What are the lasting impacts from my fall? All because this beverage. All because someone decided to unscrew the lid and I had a fall. Before I continue moving forward, it's important to note this is an important number and letter. 26F. The conference. This is when all the important parties gather together. Me, the grocery store, the judge, and we lay it all out as to what is the framework of this trial going to look like, what are the timelines, and then within 14 days of this being determined, each of the parties has to disclose the relevant information. So everything I just said about disclosing the identity of the parties, potential witnesses, documents that are related, the incident report, the insurance, the coverage, the security footage, anything that's fair game, because you need all the communication to solve the problem, which is my slip and fall, and I am not happy. There are two types of witnesses that you can encounter in a case. Those are your lay witnesses and your expert witnesses. Now, what differentiates someone from being lay or expert? Let's put it this way. An expert is someone who has the necessary schooling or the knowledge that it is to make certain assessments and draw opinions from that knowledge. A layperson is someone who just uses their observations without really having any educational background or work experience. Let's put it that way. So the old lady who was in the aisle with me when I had my slip and fall would be considered a lay witness. Now, maybe she could be considered an expert witness if she was a doctor and an orthopedic doctor who attended to my knee and tailbone, and she would be an expert because she is a doctor of bones. Now, yeah, so that would be the differentiation. So now, in order to be brought in court and whether or not you're considered discoverable means that you have to tell the other party that you exist, is one of these thresholds. And it is, are you going to testify in court or not? So if the expert witness is going to testify in court, you have to let the other party know. You have to give them documents that summarize your qualifications, what you draw your opinions on, and like what qualifies you to give this opinion that the jury could find compelling. Now, if you are only being brought upon this case as an expert witness to consult and not testify, you could be invisible. You could be a ghost. You are not discoverable, or that one party does not have to tell the other party that you exist, that you're helping out, that you are advising, that you are sharing your knowledge to help the attorneys come to plausible conclusions. Because after all, at trial, it is the battle of persuasion. Who can persuade better? Who can use words to carry out their arguments and sway the jury? That is justice. So anyways, to recap, expert witness is only discoverable, which means that one party has to disclose to the other party that the witness exists and the witness is going to testify in court. So if the witness is going to testify, you have to let the other party know. If the witness is not going to testify, you do not have to let them know. That is the difference. Do you get it? One more time. If the expert witness is going to testify in court, let the other party know, because you don't want them to be blindsided. If your expert witness is not going to testify in court, then you do not have to mention it, because they're not going to be blindsided by the information. Think about it. What's fair and what's not fair? I mean, that is the question. Are trials fair? Who knows? I'm just here trying to help you understand the process. And after Conference 26F has established the who, what, when's, why's, and where's, we know who the parties are, we know who the players are, we know what's going to happen, when the timelines are going to happen. So that's when you can start the operative word, to communicate. So what does this mean? That the plaintiff and the defendant attorneys, they just go into a room and talk to each other? Absolutely not. That would be pure chaos and nothing would get done. No, you have to do processes. So you need to submit certain documents to the court, and then the court ends up acting like an intermediary. Or, I mean, not necessarily, like you serve... Okay, you serve to the other party written documents, because you need to have written proof that things are happening. So that can take the form of a deposition. You can sit down with another party, so like not the attorneys, but the parties, and any other person that is relevant to the case, and ask them questions. So you go into a room, it has to be reasonable, it cannot be more than a day, it cannot be 12 hours of incessant questioning. No, you go in there with a purpose. You ask the questions, you get answers, it's all under oath, and then it could be used later at trial. That's when they say, oh, but you said this at your deposition. That is when the person is being deposed. the person is being asked questions and the person has to respond to the questions. Now, either party can depose anyone that they want. That's how the cookie crumbles. Then we have interrogatories, which are questions. You can send interrogatories one party to the other. So plaintiff can send defendant 25 questions. There's a limit. You can't send more because that's ridiculous. And you can of course send less, and you can send compound questions, but they have to be within the 25 question limit. Yeah. So me, the plaintiff, decides to send, well, my attorney. I'm an attorney. Anyways, my attorney, the plaintiff's attorney, decides to send a list of interrogatories to the defendant, the grocery store. We'll ask certain questions like, how often do slip and falls happen? Defendant goes, answers. Who knows what the answer is? Who was working at the store that day? Who was the manager? Were the security cameras working? Can you see who uncapped the bottle? Things like that. You know, you want to ask questions that you want answers to. Then the defendant can come right back at you. Now, it's important to note that interrogatories are only between the parties. You can't just go and serve a non-party. A non-party is a party that is not part of the litigation. An interrogatory, because that is not how it works. Then you can request production. One party can file a motion for the other party to produce certain documents or media, and that could be me, the plaintiff, requesting the production of the grocery store security footage to show I indeed did fall because the beverage spilled, and not because I was trying to make some easy money at the expense of my injuries, if you catch my drift. So I can request that security footage. I can request a document showing who was working that day and things like that. Anything that is pertinent and relevant to the case. I can't ask the other party, oh, can you produce the lunch schedule for your employees? Is that relevant to my slip and fall? No. Unless maybe you say, oh, this person was supposed to be working, but this person was in lunch, and to show negligence. But more particularly, you cannot ask, oh, what car does the employee drive? That has nothing to do with my slip and fall, so it's not relevant. What else? Oh, you can request a medical exam of the plaintiff. And that's only possible if there's good cause and if your health is a main part of the litigation, of the issue, of the injury in fact. In this case, it would be because I had a slip and fall, I hurt my knee, and I hurt my tailbone. I went to the doctor. The other party can request that I get a medical examination by 2 independent doctors. Yes, that is possible because my condition is at the forefront of this litigation, whether there's fault or not. Now, if this was a contract case of a breach of contract of paying someone for services rendered, such as that I was painting and someone didn't pay me back, so I sued for breach of contract because I performed, I painted the house, and then the other person decided not to pay me. Requesting a medical exam has nothing to do with the case. There has to be a correlation in order for you to invoke a medical exam. It gets a little dicey when mental health is in play, but if there is a question about whether this person understood the consequences of their actions, and you get more into the nitty-gritty test, but that's for later because right now we are in civil procedure and discovery. Finally, you can request for admission, and that's basically saying, tell me if you're lying or not. Tell me if you admit this fact or not. And it's easy as that. You can admit or deny, but you can never leave it unanswered because that will be automatically considered an admission of guilt, of yes. So I've been throwing a whole lot of phrases at you, but let's try to review a bit. A deposition is when you ask questions to a person. Does not have to be a party named in the case. Could be a non-party. Interrogatories are only for the parties, the communication between the two parties, all written, so you can refer to it later. Medical exam only if your health is the subject of the controversy. Request for production only between the parties. It's gathering the information because you're trying to figure out what everybody knows, because you want to make compelling arguments. You want to represent your client in the best possible way. You want to offer the relief. And what is the best way to offer the relief is you have all the information. If you have all the conversations, if you have all the expert testimony, if you have the lady who saw you slip and fall, that's a lay witness. She has observations because she was there. You can further corroborate that she was there because the grocery store has video footage that shows the lady watching as I was grabbing the beverage from the shelf, spilled all over, and I had a slip and fall. All of these moving parts move together, but it's important that you follow the rules of civil procedure. Like I said, Rule 26F is what dictates how the trial is going to move forward, and you need to abide by it. You need to send these requests within specific days. I mentioned within 14 days. If you do not do that within 14 days, you can suffer some penalties, and you do not want your case to be thrown out for technicalities. So pay attention. And also in the bar exam, they will get a little dicey with dates and numbers and within how many days and what happens after all these days, but try to think of the big picture. Communication is the theme of discovery. You need to make sure everyone is on the same page, because technically that would be fair. That's when fair conversations can be had. Discovery is such a beast, and it would only be fair to give it the attention it needs. In the next video, I will have a discovery part 2, where I would go more into sanctions and other requests, other motions, other notices that come into play in the belly of the beast, what makes the case beat. And anyways, as promised, I will now include my chart. And good luck studying. Keep it up. I know it's hard. It sucks, but once you put in all the work and understand the big picture, it's very rewarding. And see you next time. Actually, let's just keep going. Now, relevancy. We have requested all this information, and I've alluded to relevancy, saying whether interrogatories are relevant to the case or whether the deposition topic questions are relevant to the case. It needs to be proportional. The questions, all the information related to the claim must be proportional to the needs of the claim. What does that mean? It means what it says. It has to be related. What you're asking, what you're requesting has to be directly related to the case. Asking me, what color was the beverage? Was it blue or orange? Is that really going to go down to whether or not the grocery store is at fault for my slip and fall? I mean, some people may put a twist on it and say, oh, I say orange, but in the video it comes out blue, so it proves that I'm lying. It could prove that I'm colorblind. Actually, I don't know how that works, but it has to be relevant. You can't be asking the grocery store, oh, do you make contributions to charities, specifically the animal shelter down the block? Is that relevant to my slip and fall? No. So, would it be admissible? Just try to use your common sense. Now, a party might say, I'm not going to release that information to you that you've requested. Those questions that you've answers to, the media that you've requested because it is privileged work product. What does that mean? It means that somebody took the time in anticipation of litigation with mental impressions to create a plan of attack and use that media for the plan of attack. And if that person were to give it to me, then would dissolve the whole argument. And that's not fair because I'm giving away my thoughts, my conclusions, my opinions. So what happens? You have to prove that you have substantial need and that it is essential to the case. You have to meet the burden of proof in order to make that information that that party is saying is privileged otherwise discoverable. So just because something is privileged doesn't mean that it's no longer discoverable or available for communication. It just means that you have a higher burden of proof. Sometimes it works, sometimes it doesn't. You have to show the substantial need and that there's no other way to get that information. Suppose the grocery store says, hey, I can't release that video footage because we're using it as work product. We used it to create our arguments, but then I can come around and say, no, this is essential. It's substantial to my case. That's the only video available. There's no other video. How am I going to be able to prove my case, my argument? Then the judge sits down and says, okay, let's hear your arguments for each position. And then the judge decides whether or not that will be admissible. You can compel the other party to offer a full response. Sometimes, like I said, it happens in life too. Someone can give you a half answer. And what is a half answer? An answer that is not complete. I can ask you, what is your cat's name and the breed? And I could say, Elton. What happened to the rest of the question? What breed? That's a partial answer. So then the other party can file a motion to compel a full response, enforce it, and be like, okay, we understand that you answer what's the name of the cat, but what is the breed of the cat? Then I have to answer, or if not, I can get in trouble because you know what? We need to have communication. The communication needs to flow. If it is not flowing, if it is not complete, that's what it is. It's not complete. So parties can compel the other to give a full response or to elaborate or to better answer the questions because they could ask you, what beverage were you taking? And I could say the name of the brand of the beverage. And then maybe that's not enough. Maybe they wanted me to talk about the texture or the volume inside the bottle. But you know what? They didn't really specify that. But then they can just come with more specific questions. It's in the realm of follow-up questions. And that happens a lot in conversation. You'll be talking to someone and they'll mention something and then you will ask a question to elaborate more because that's how conversations work. If you're listening, if you're being a good active listener, other questions will flow from the original questions. Okay, now what happens if you have no answer? You ask the party a question and the party just doesn't answer. You file a motion to compel the answer and ignored like a ghost. Just erasing you from existence. Well, erasing you from existence. So what happens? You filed for them to get a sanction. And what's a sanction? Un pau pau. You're going to time out. You've been behaving bad, so you must be punished. What do sanctions come in the form of? Attorney's fees, monetary fees. You can get suspended. Who knows? Depends on the severity of the infraction. So you don't want to go to detention. You don't want to get that slip. You don't want to have to pay a fine in court for not answering a motion, for not answering interrogatory, for just not being a good sport. You don't want ese pau pau. You want the praise. You want a good job for following instructions. Don't be the rebel. This is not the place to be the rebel. So, to summarize, sanctions aren't bad. You don't want that. That reflects poorly on you. So, follow instructions. When you're asked questions, answer them fully. If someone asks for more information, provide more of the information. If you think it's privilege, say, hey, it's privilege. And if they want to push on it, well, the burden falls on them to prove that they can get at least part of the information. Communication. No one can read your mind, so you need to lay it all on the table. Okay. Now for real, this is it. I ended up covering discovery all today, so enjoy. It's very complicated, but like I said, once you get the big picture, it's easier to see the details for what they are. See you next time, and please subscribe.